Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and the options that you have concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your more serious type cases. Whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case, the possible punishment that a person can receive if they are convicted of this particular offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. Now, if a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, the case that you have in this court is a misdemeanor case, so you don't have to worry about those type punishment. Misdemeanor cases are divided into 3 categories. We start at the top, work our way down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanors are cases that start in the city court, which is the municipal court, or the JP court, which is the justice court. They come to this court when the person is found guilty or convicted in one of those courts, and they appeal their case. When they appeal their case, they get a whole new trial. But the punishment range is still the same. And so for Class C misdemeanor, the range of punishment is fine only. The fine cannot be above $500. So anywhere from $1 to $500 is the range of punishment for a Class C misdemeanor. An example of a Class C misdemeanor will be not having your seatbelt on, speeding, having expired license plate sticker, those type cases. Now, the Class B misdemeanor, which is the next highest misdemeanor, the range of punishment for Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor, and the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation is a form of probation that we normally refer to as deferred adjudication. That simply means that you will not have a conviction on your record. And if you successfully complete that type of probation, the case will be dismissed and you may qualify for what is called a non-disclosure. Non-disclosure is where your record is sealed to the general public. That is, the general public cannot have access to your record. Now, the opposite word that I use is general public. The government and certain government agencies that are listed in the Texas Code of Criminal Procedure can have access. But most of the public is general public, so they cannot have access. So if you apply to a job, say with Exxon Mobil, and they check your record, you had a non-disclosure, it's sealed to them, they will not be able to see it. Okay. Now, the next type of probation is called adjudicated probation. You have unadjudicated probation and you have adjudicated probation. With adjudicated probation, we normally refer to it as regular probation. It does result in a conviction and record. However, there is something that is called judicial clemency. Judicial clemency means that the judge, the court, can set aside your conviction, which means you will no longer have a conviction. And if you do everything that you're supposed to do to get it, then the judge can set it aside. For example, in order to qualify, three things has to happen. One, it has to, you have to successfully complete probation. Two, there cannot be any more time left on the probation. And three, the probation department has to successfully discharge you or let you off of probation. And if those three things happen, then the court has the discretion to set your conviction aside, which means you will no longer have a conviction. However, if you get a subsequent conviction, that is, if you get a conviction later on, then the case that you received judicial clemency on can be brought back up. It can be resurrected, revived, brought back up, and it can be used against you. Now, if you try to get a license with Child Protective Services, they can either deny giving you a license, or if you have a license, they can suspend or revoke that license. Now, everyone here, for a case, you should have a clipboard. There's some paperwork on that clipboard that I'm going to go over with you, and it talks about your right to have an attorney. This first document that is titled Judge's Explanation of Rights to Defendants Without Attorney, and we're going to constantly refer back to this document. It states that as a defendant in a criminal case, you have three options. And it says, number one, you may hire your attorney. Number two, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. That is, you can waive your right to an attorney and represent yourself. Now, first, one sentence paragraph under number three states that if you would like to hire your owner, if you like to hire an attorney, you have enough money to hire your attorney, then your case will be reset. It means that you will be given another court date to give you time to hire your attorney. The next paragraph below that states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Now, you must first sign a financial questionnaire to see whether or not you qualify for a court-appointed attorney. Now, the financial questionnaire is a 3-page document that is also on the clipboard. Now, this is only for people who will be applying for a court-appointed attorney. So if you're not applying for a court-appointed attorney, you don't have to worry about what I'm getting ready to say regarding this document. Now, this document states that Jefferson County Affidavit of Indigence, that's the title. For those individuals who would like to apply for a court-appointed attorney, you will fill out the first page of this document. And then you'll go to the second page And at the top, it says defendant's oath. You fill out this section. And then you go to the middle portion down here that says unsworn declaration by defendant. And then you'll stop. Now, going back to this first document, the third paragraph is for people who will be waiving their right to have an attorney. And if you're waiving your right to have an attorney, that simply means that you will be your own attorney. But it states that you may not talk to the prosecutor unless you first sign a written waiver of your right to proceed without an attorney. Now, the written waiver is another document that is on the clipboard. This is only for people who will be representing themselves. This document is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You'd have to read and sign this document, and you're signing on the line that says defendant, and you date it today's date. Now, going back to the original document, below the paragraph that says you may not speak to a prosecutor unless you first sign a written waiver, there's another paragraph in block form for individuals who will be representing themselves. This paragraph states that be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you, including your case. It also states that you may lose significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, last paragraph right here states that this is for individuals who will be representing themselves. It states that if you're representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you're representing yourself, and because you're representing yourself, you're your own lawyer, just like a lawyer could talk to the prosecutor. We have a prosecutor here in court. He's an assistant criminal district attorney with Jefferson County District Attorney's Office. Just like your lawyer can talk to him, you can talk to him. And you can talk to him to see if you can negotiate, work out something on your case. You know, when we say that, when you're trying to settle your case, and if you're settling your case, we call that a plea bargain. And so you can talk to the prosecutor to see if you can work out a plea bargain. Let's say you might have in mind that, hey, I would like to get probation on this case. You talk to the prosecutor say, well, I'm not offering probation on the case. I'm offering jail time, or I'm offering a fine. And then you say, well, I don't want that, judge. I changed my mind. I like to apply for court-appointed attorney. Okay. Now, at the bottom of this document, in bold letters, it states defendant's choice. Mark initials next to only one choice. Now, everyone that's here for a case is going to mark your initials on one of the 5 lines. Okay. If you would like to hire your own attorney, then you'll place your initials on the first line to the left. Okay. Then you will sign at the bottom, your signature, date it, and then you'll stop. And this is the only form that you would have to sign. If you have already hired an attorney, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. Then you'll sign where it says defendant and date it today's date, and then you'll stop. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left, sign the form at the bottom on the line that says defendant, and then you will date it. And then after you do that, you will fill out this form that is titled Jefferson County Affidavit of Interest or Affidavit of Interest. You'll fill out the first page of this document, And then you go to the second page, on the second page at the top where it says defendant's oath, you'll fill this portion out. And then you go to the middle portion where it says unsworn declaration by defendant, and then you'll stop. Now, going back to the original form, on line number 4, it states that if you have already been appointed a court-appointed attorney in this case, you'll place your initials on the 4th line to the left and the name of the attorney on the line to the right. And then you'll stop. This on the form you have to send. Now, if you like to waive your right to an attorney, that is, give up your right to an attorney and represent yourself, then you'll place your initials on the 5th line to the left, sign the bottom of this form that says defendant, dated today's date, and then you go to this form that is titled waiver of counsel for purposes of entering guilty plea or proceeding to trial. You fill out, read and sign this form, you sign what says defendant, dated, and stop. Okay, do we have any questions before I go on any further? Okay, all right. Now, the next thing we'd like to talk to you about is that you have a right, well, you can enter a plea of either not guilty. If you enter a plea of not guilty, you tell the court that you did not commit the offense that you've been charged with, or you can enter a plea of guilty. If you enter a plea of guilty, you tell the court that you committed the offense that you've been charged with, or you can enter a plea of no contest. If you enter a plea of no contest, then you're telling the court that you will not be fighting or you will not be contesting your charge. Now, you have a right to have a trial by jury. Now, in this area where Deputy Butler is sitting, we call it the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. Now, in a misdemeanor case, you have 6 jurors. In a felony case, you have 12. But in a misdemeanor case, you have 6. So 6 jurors will be selected to serve as jurors in your case. They will listen to all the evidence that's presented by the state and the defense. They will listen to the arguments of the state and the defense. Then they will retire to deliberate in the jury room, and they can either find you not guilty or guilty. Now, you can waive your right to have a jury trial, meaning that you can give up your right to have a jury trial. Now, you still can have a trial. You can have a trial by judge. We call that a bench trial. That's the reason why they call it a bench trial, because the judge sits on the bench. And so the judge will be the judge and the jury in the case. And so the judge will listen to all the evidence presented by the state and the defense, the arguments by the state and the defense, and then the judge will apply the facts of the law and decide whether to find you not guilty or guilty. Now, you also might decide to enter a plea of guilty or no contest. So if you enter a plea of guilty and no contest because you want to see if you can work out a plea bargaining agreement with the state, and if you are able to work out a plea bargaining agreement with the state, that plea bargaining agreement comes before the judge. And then the judge can do one of 2 things. The judge can accept or reject your agreement. Now, if the judge accepts your agreement, well, let's say if the judge rejects your agreement. If the judge rejects your agreement, then you have a right to withdraw your plea. In essence, you enter a plea of guilty, no contest, you got a plea bargaining agreement that you want to accept with the judge. You went before the judge and just say, I reject it. And you say, well, judge, I take back my plea of guilty and no contest. You have a right to do that. That says that you have a right to withdraw or take back your plea. Now, if the judge does accept the plea bargaining agreement, then let's say within 30 days, you decide that you would like to appeal your case or you like to file a motion for new trial. And in order to do that, to appeal your case, you have to get permission from the judge that filed the plea bargaining agreement. If the judge gives you permission, then your case is going to leave this court here. And it's going to go to the 9th Court of Appeals. Guess what? 9th Court of Appeals is right above us on the 3rd floor. The 4 judges up there, they can do one or two things. They will review your case. They can do one or two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Case over. Or they can send the case back down to this court, or in this court to give you a whole new trial. Now, if they deny your appeal, no problem, because you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your court case to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. They're located in Austin, Texas, and you have to file what is called a pro se petition for discretionary review. I will explain that to you. Pro se means self, I'm by myself. I don't have a lawyer. I'm petitioning Texas Court of Criminal Appeals to review my case to see whether or not my appeal should have been granted, or whether or not this court committed an error by wrongfully convicting me. Now, the Texas Court of Criminal Appeals can do one or two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty, or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down here with orders. Now, if they deny your petition for your pro se petition for discretionary review, then at that point, your conviction will stand. Now, you also, in reference to you having a plea bargain, let's say you and the state have been unable to agree on the punishment that you would like to accept. Well, then you still can go forward on your plea of guilty and no contest. You can go to the judge on what we call an unagreed plea bargain. In essence, you do not have agreement with the state, but you want the judge to decide what your punishment should be. And that's the judge will decide your punishment anywhere within the punishment range of your offense. Okay. Now, you also have a right to have witnesses to come to court. Witnesses sit in that chair that has the microphone, in front of it. We call that the witness stand. Witnesses could do one or two things. They can testify for you or against you. If you represent yourself, you can ask them questions. You have an attorney, your attorney can ask them questions. We call it either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses, meaning that you will now be calling witnesses to testify in your case. That does not mean that the state will not be calling witnesses, because they will be calling witnesses to testify. Now, you also have a Fifth Amendment right against self-incrimination. What that means is you have a right not to say anything in your case. The United States, the Fifth Amendment of the United States Constitution gives us a right to remain silent, not to say anything that can incriminate us in our case. And so, for example, a lot of times we watch television, we see television lawyers go up to the witness stand and ask one of the witnesses a question. The witness says, "I take the fifth." Well, what they're saying is, I'm exercising my Fifth Amendment right against self-incrimination, not to say anything. And if you think about it for a minute, it makes sense to have a Fifth Amendment right. And the reason why it makes sense is because the state of Texas, or the district attorney's office, has the burden of proving you guilty beyond a reasonable doubt. You don't have to prove yourself guilty, okay? Beyond a reasonable doubt. It's their burden. They have to prove that you're guilty. So you can invoke your Fifth Amendment right against self-incrimination. Now, you can waive it, which means that you can say, well, I would like to testify. You can do that if you desire. Now, the other thing is you have a right to have what is called discovery. And what discovery basically is you have a right to see the evidence, have access to the evidence that the state has in its file. For example, you have a right to see witness statements, your statements, police reports, lab reports. You have a right to see video recordings, listen to audio recordings, right to see photos. You have a right to see documents, insurance, whatever evidence that they have that they'll be using in your case. You have a right to have access to that, and we call that discovery. Now, you can waive or give up your right to have discovery. If you do so, that simply means that you will not be having access to the evidence that the state has against you. Now, everyone here today that has a case in this court, charges was filed on you, you was arrested, placed in Jefferson County, placed in jail, and you bonded out of jail, you get out of jail a cash bond, which means you paid the full amount of the bond to get out of jail. You out of jail on a surety bond, which means that you pay a bondsman percentage of the bond to get out of jail. Or you're out of jail on what is called a cash bond, or on a PR bond, which means that you did not have to pay anything. You also have a personal recognizance bond or PR bond. You didn't have to pay anything to get out of jail. You was released under your own personal recognizance with a promise to appear today. I said that to say this. Every day that you spent in jail, it can be used as credit toward your punishment. So, for example, and the operative word that I use is every day. Okay, so for example, let's say you were arrested at 11, well, you're not only arrested, but you was booked in jail at 11:59 p.m. last night. And 2 minutes later, at 12:01 a.m., you booked out of jail. Okay? So you was in jail 2 minutes, but you get credit for 2 days. And the reason why you get credit for 2 days is because they're 2 different days, right? We have Monday and Tuesday. So it's 2 different days. And so it's not like you was in there, you have to be in there 48 hours. It's just the 2 different days, whenever that happens. Okay, so let's say, for example, you spent 5 days in jail and you would like to talk to the district attorney's office, and they're offering that you serve 5 days in jail. You won't have to serve any more time in jail because the time that you have spent in jail, you'll be given credit for that. We call it credit for time served. Okay? Now, if they offer 7 days in jail, you spend 5 days in jail, that simply means you would have to spend 2 days in jail. All right, because you have 5 days credit. We subtract 5 from the 7 and leaves 2. Now, every day that you spent in jail also could be used as credit towards your fine and court costs. So, for example, every 1 day that you spend in jail, you're accredited at $100 per day. Okay? So if you spend 5 days in jail, that's $500. So if the state is offering you fine and court costs of $500, you won't have to pay anything because the time that you spent in jail has already paid it off. It's taxed and retired. Now, if they're offering fine and court costs of $700, you spend 5 days in jail, which is $500. We subtract 500 from the 700, that leaves $200 that you would have to pay when your case is disposed of. Now, if you cannot pay the balance on the day that your case is disposed of, which is $200, no problem, because we could put you on a payment plan. And so we put you on a payment plan, you can pay off the balance in small monthly installments until it's paid. Now, if you cannot pay in small monthly installments, no problem. Because we can convert the fine and court costs to community service. And for every 1 hour of community service that you perform in a nonprofit organization, you will receive $12.50 that will be credited towards your fine and court costs. So if you work 8 hours, 1 day, that's $100. Okay, so in our scenario, you work 2 8-hour days, that's $200, your fine and court costs is paid off. All right. Now, Jefferson County has a program for individuals who haven't been in trouble. When I use the term trouble, haven't had convictions before. We call that program the pretrial diversion program. And the reason why I bring it up is because that program is run through the district attorney's office. But what they would do, they would dismiss your case. And you could get it wiped off your record. We call that expunged from your record. Now, in order to qualify for the program, that program, 3 things has to happen. You have to have an attorney to assist you with the application process. The attorney could be an appointed attorney, doesn't have to be it could be a court-appointed attorney, doesn't have to be one that's hired, just any, attorney to help you with the application process. The next thing is, it cannot be for an offense involving unlawful carrying a weapon or resisting arrest. And again, as I mentioned to you earlier, it has to be your first time, actually getting into trouble with this case or the cases that you have. All right, now, if you are a veteran of any one of the military branches, Jefferson County District Attorney's Office has another program that is called Veterans Court. That program is for veterans only. Doesn't matter if you had an honorable or dishonorable discharge, you're a veteran, okay? You just have to be a veteran. With that program, Veterans Court, once you get into the program and complete the program, they will dismiss your case. And you can get a non-disclosure whereby your record is sealed to the general public. All right. Now, this court, County Court at Law number 2 of Jefferson County, Texas, has a program that God led me to start within the first 100 days of taking office in March of 2017. That program is called the CSI program. It's an acronym, CSI, that stands for Community Safety Initiative. The program is designed to address the issue of what we call recidivism. Recidivism just means people commit crimes over and over. And so with the program, we have partnerships with agencies in our community. One of the agencies that we have a partnership with is Spindletop Center. Spindletop Center is our local mental health center in the Southeast Texas region. And we have folks from Spindletop that will come to you in a few minutes and tell you a little bit more about the program. But basically, what Spindletop will do, they have the expertise to address your mental health needs. For example, you do not have to be incompetent or insane to participate in the program. You could just merely suffer from anxiety or depression or any other host of mental illnesses, and they have the expertise to address your issues. Now, basically what Spindletop will do today, they can do a private interview in our jury room at their facility or by telephone, whichever is convenient for you. They can do an assessment to determine what that problem is, and they can develop a treatment plan to address the problem that you may have. If you have issues with drugs and alcohol, well, Spindletop has another program that is called ATAR, ATAR, that stands for Addiction, Treatment, and Recovery. And we also have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR, OSAR. It's an acronym, stands for Outreach, Screening, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do, they would conduct a screening, they would have a treatment plan that they can use from the assessment that they're going to give to determine what your drug and alcohol needs are. The treatment plan could be either outpatient, inpatient, whichever is they think is appropriate to address your drug and alcohol issues. If you are unemployed, or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. CICE is another acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in any one of those areas that you select, they will help you to get a job in the area that you're trained in. Now, if you have not graduated from high school, or if you do not have a GED, well, they have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 of Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, but what comes out of the home goes into the community. And so if you're interested in any one of these programs that I've just mentioned, just let us know and we can get you started on living your best life. So at this time, I would like to have Caitlin and Deputy Butler come before you and tell you a little bit more about the program that Spittletown has to offer. Thank you.
Good morning, everybody. I'm Deputy Butler in Jefferson County Sheriff's Department. I work along with the Spittletown program. I'm one of the mental health deputies. And this is my partner here, Ms. Caitlin. She's a qualified mental health professional. If you become a Spittletown client, she'd be the one that you speak with. Our part as assisting the Spittletown is to assist you in transportation. If you became a Spittletown client, it's assist you in the transportation, which will get you there to a doctor's appointment and back home if you don't have any transportation. The form that you have before you, Ms. Caitlin, she'll explain that to you more about it and give you a little bit more understanding of what this program is all about.
So on the small form on the front of your clipboard, there should be like a little half paper. That is our document. It is not a court document. It is optional. You do not have to fill it out if you do not want our resources. And whatever you put on that paper is protected between me and you and HIPAA. I don't tell the court, I don't tell the judge, I don't tell anybody without your permission. So our resources is mental health. It could be PTSD, depression, or anxiety. And what we offer is talking to a doctor and getting mental health medications, if that's something that you want. Talking to a counselor, getting you therapy, that type of thing. And for substance use, it's any type of drug or alcohol. We have a substance class, we have support groups. We can even help you get into an in-house rehab or an out-house rehab. And if there's a resource that you've heard about that I haven't offered, then we can help you find that, or I'm pretty sure we can send you some resources that we already have. If you'd like to talk to me today about getting into Spittletown services or helping you find a resource, just write on your paper, please talk to me today. And I will pull you to the back of privately while you're there at court. If you rather write calls, there's an option for you to check that as well. Again, you don't have to fill this out. You can leave it blank. We can always use the extra paper. Anybody have any questions?
Hi,
Yes, sir.
that part about helping, find a job, like training.
Yes, sir.
That part,
Okay, if you write your email on the paper, I can just send it to you and we have a link of resources, like a list. So if it's not something you want to talk about today, then I can just email you the list, you can go through it yourself if you're interested.
I have a question, but
Yes, sir.
working on already, you were diagnosed with receiving services.
Wait,
You
sorry.
have not you spent time, but through National Smart Health Piece.
Would you like services out there in Beaumont?
I'm a resident of Houston.
Mhm.
I got caught up here in Beaumont because of my addiction.
Mm-hmm.
So I've been free through mental health services and AA programs for a year and a half ago. And the record shows in the court that I was in and out of here, in and out of here, in and out of here, until I got that help.
Yeah,
And I've been free of drugs and alcohol for a year and a half now.
yes, sir.
Got my life back together. And I am trying to become, I do have life coach, spiritual coach, counselor,
Yeah.
caseworker.
Yeah.
I mean, and I depend on all that
Yes, sir.
to keep my sobriety, keep having this productive life that I found
Mhm.
through my heart. And does that apply here?
Yes, sir. If you have, even though we don't work with the people in Houston, if you have any caseworkers or rehab sponsors that you can use as like a testament for you, somebody that we know that's already helping you, we can work with them, or if the judge requires it, you can also have them reach out depending on your case. Now, it's not a guarantee that that's something that he would request from you, but it just depends on how your case goes.
Thank
You're welcome. Anybody else? Yeah, thank you guys.
Thank you. Caitlin and Deputy Butler. Now, ladies and gentlemen, the forms that you have, we're gonna pick those forms up from, and then we're going to put you into one of three categories once we make sure everything is filled out properly. One category that you can be placed in is the category to hire an attorney. If you're placed in that category, then your case will be reset today, meaning that you'll be given another date to give you time to hire your attorney. Second category is if you would like to apply for a court-appointed attorney. If you qualify for a court-appointed attorney, the attorney will be appointed today before you leave. And the last category is if you would like to waive your right to an attorney, that is, give up the right to have an attorney represent yourself, then you'll have an opportunity to talk to the prosecutor. If you're able to work out a plea bargain agreement, then your case will be taken care of today. Now, it's gonna take us a few minutes to pick up the forms, make sure that they're filled out properly, and then we're gonna call you up to the bench one at a time. If you need to use the restroom, there are two restrooms in the hall. We have the mid restroom in front of County Court at Law number 3. And then on the opposite side of the hall, in front of the 172nd District Court, we have the women's restroom. Now you'll be allowed to go to use the restrooms. Please do not leave the courthouse. If you leave the courthouse, your name is called, and you did not answer, your bond will be forfeited. If your bond is forfeited, warrant Bishop for your arrest, you'll be arrested, placed in the Jefferson County Jail, hopefully you bond out. Then we'll have to go through this all over again, okay? And so, we're gonna try to get you, out of here as soon as can. Now, if you need any help with your form, we have our court personnel, including myself, who will be happy to help you finish filling out the form properly. Now, I forgot to mention that at the top of the form, it states State of Texas versus, and then there's a line that says blank. Print your name on that line. Do not write your signature, because a lot of times we can't read the signature, but we can, if you just print your name, we'll know who the form belongs to, okay? So be mindful that we're still in court, so conduct yourself accordingly. Do we have any questions?
I do,
Okay,
I'm gonna do again, I got signed the bottom.
that's, you represent yourself?
Yeah.
Yeah, initial, sign, and date, you did that. And then there's another form that says, waiver of counsel for purpose of entering that form right there, you gotta read and sign and date that form. Okay? Anybody else? Okay, so we'll be in recess, make sure that you conduct yourself accordingly.
If you're done, you can meet me at the table and bring me your paperwork.
And the, okay, the people that's on Zoom, make sure you, your, videos are off. And, we're gonna get back to you to, give you a court date. Thank you.
I can't hear him. I can't hear him.
No. Can't help it, bro. I'm looking at this shit. You know, man, no.
Okay, Ms. Hargrave, please put your mic on mute and turn your video off. And then when we ready for your case, we're gonna call it back up. Thank
All
you.
right, thank you. My video off? Oh my God, I just missed him. No, here it is.
Slow down.
Oh, Jesus Christ. Help me, Greg. Oh, God.
You got to read the daggum poem, okay?
Okay.
I can't. Be careful. Sit down. Sit down. Sit down, please. Knock him out.
That's fine. Thank you, babe.
Josh, I already took off on mute. I already put on mute, so. It's not at all, it's just technology.
Whatever you do.
The best thing to do when you turn it off, turn it back on, they actually put muted on your video. Okay. So that's, is that cold? Borrow. See. And.
All the ones that wanted to represent.
Yeah, I got it.
All of those
Sorry, yes,
to represent themselves?
yes.
Okay, I meant to give it to them first, but,
No, I had to put the number in
okay, all right.
the same. Okay. So this is, code.
All right, there's lots. Go back to the one you came to.
Oh, goodness. We need to get some court dates.
Mm-hmm. Put them back on that.
Yeah,
Here it is.
yeah. Okay.
Yes, sir.
It's gonna be Miss Hawkins,
Aubrey.
Hargrave.
Yes, sir.
Yeah, give us a quick date,
30 days.
2.
Okay.
Hold on, Miss Hargrave.
Yes, sir. I'm just trying to hear you, sir.
Okay, hold on a minute. What is that date? Okay, your case is gonna be reset to February 10th at 9 AM in County Court at Law number 2. Stay in contact with your bondsman. It's February
Okay.
10th at 9 AM. Now you're free to
Okay.
go, and you have a blessed day.
Thank you so much.
You're welcome. And give us another date on Mr. It's 45. Yeah. Montez Lewis. Okay, Mr. Lewis, give us a date.
Yes.
Hold on a
Yes.
minute. Hold on a minute.
Okay.
Okay, this case is gonna be reset to March 17th. Did you hear that?
Yes, March 17th. Yes.
Yeah, March 17th at 9 AM.
Okay.
Okay, stay in contact with your bondsman. You're free to go and you have a blessed day.
Okay, sir.
Okay. Jefferson County Court Law Number 2 is back in session with the arraignment docket. First case is cause number 25 CCCR 2734. Case is style of state of Texas versus Brioja Keel. Ms. Keel, would you please come forward? Good morning, Ms. Keel. Did I pronounce your first name correctly? How do you pronounce it? Riaja? Okay. So Ms. Keel, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing? I'm doing fine, thanks for asking. Ms. Keel, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Now, before you sign this document, did you read the document?
Yes.
Did you understand what you read? Is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Ms. Keel, your case is going to be reset to give you opportunity to hire your attorney. Our court coordinator is going to reset your case. Once she resets your case, you're free to go. You have a blessed day. Please have a seat in that first chair on the wall. Next case is Eric Dean Coleman. Mr. Hilton.
Yes.
Okay, Mr. Coleman. Your full name is Eric Dean Coleman.
Yes, Your Honor.
Mr. Coleman, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Mr. Coleman, you may put your hand down. How are you doing, Mr. Coleman? Ma'am, that door is locked.
Thank you, Your Honor. I'm still getting through today.
That's good. Now, Mr. Coleman, the state is represented in this case by Attorney Shan Hilton. Attorney Hilton, how are you doing?
I'm good, Your Honor. Thank you.
And Mr. Coleman, before we go any further, I need to inform you that you have a right to have a record of this case. That is, you have a right to have the court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a record in this case. Do you waive or give up your right to have a record?
Wait a minute.
Okay. Now, Mr. Coleman, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Eric Dean Coleman, on or about September 3rd of 2024, while you were in Jefferson County, Texas, that you committed to Class B misdemeanor offense of possession of a controlled substance, penalty group 2-A, that had a weight of less than or equal to 2 ounces. Mr. Coleman, do you understand what you have been charged with?
Yes, Your Honor.
And to this charge, Mr. Coleman, how do you plead? Not guilty, guilty, or no contest?
Put guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you are guilty? Okay, Mr. Coleman, I also have before me a document on my tablet that is titled misdemeanor plea admonishment. This document is also labeled as State's Exhibit Number 1. You recognize this document?
Sure.
On page 2 of this same document, there are 2 sets of initials. First set of initials are on a line next to a box that says check guilty. Did you place your initials on this document?
Yes, Your Honor.
The second set of initials is on a line next to a statement that reads, I waive my right to discovery, but I do not want discovery in this case. I will waive my right to discovery in this case. And I choose to enter a plea of guilty and no contest. Place your initials in the second location.
Yes, sir. Your Honor.
On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
On the next document that's titled trial court certification of defendant's right of appeal, you recognize this document.
Yes.
Is this your signature?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Coleman, I also have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that states you would like to waive your right to an attorney and represent yourself?
Yes, sir.
And I have a document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding the Trial. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Coleman, before you sign and initial all of these documents that I just showed you, did you read the documents?
Sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Coleman, are you a citizen of the United States?
Yes. Yes, sir.
State?
State will offer State's Exhibit 1.
Now, Mr. Coleman, the state is offering State's Exhibit Number 1 to be used as evidence against you. State's Exhibit Number 1 is the first document that I showed you on this tablet that's titled Misdemeanor Plea Admonishment, which is State's Exhibit Number 1. On page 2 of this document, this is the same document that have your initials in these 2 locations. And it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objection. State's Exhibit Number 1 will be admitted. Mr. Coleman, is there any evidence that you're currently mentally incompetent to stand trial?
Yes, sir.
There is evidence that you're incompetent?
Yes, sir.
Do you understand what incompetence means?
I do.
Okay, now incompetence saying that you don't even understand what you've been charged with.
I'm doing diagnosis. I saw.
Okay, that's- I understand that. But I didn't ask you if, okay,
I'm sorry.
there's a large spectrum of mental illnesses. But competency, one is to determine whether or not, one, you understand what you've been charged with. And do you understand
Yes, sir.
what you've been charged with? And 2, do you understand the legal consequences of you pleading guilty? Okay. And hold on a minute. And do you understand now, are you entering into this plea freely and voluntarily?
Yes, sir. Yes, sir.
Okay, nobody's forcing you to enter into this plea?
No, no.
You're not going through some type of mental episode as we speak? That
No, you're-
that inhibits you from understanding the process?
No.
Okay. And you understand not only what you've been charged with, but also the facts, all the circumstances of your case,
Yes, sir.
okay? And you understand what we call the adversarial nature of your charge. Adversarial means that you have the state on one side, the defense on the other side. If you representing yourself, you the defense, and the state is representing the state of Texas. You understand that basically you all are kind of like you're opposed to each other. It's kind of like, for example, I like to use an example of being in a boxing ring. Okay, you have one person in one corner, the defense. You have another person in the other corner, the state. Right?
Yes,
So that's why we have two separate tables here. You have the defense on that side, state on that side, right?
yes, sir.
And the state presents evidence. If, for example, when a trial, the state presents evidence, defense can present evidence, or they can rebut the state's evidence, and the state can do the same thing with your evidence. Do you understand that?
Yes, sir.
Okay. Okay, so Mr. Coleman, the court is going to find that you are mentally competent to stand trial. The court will accept your plea of guilty. The court will find that your plea and waivers were freely and voluntarily given. And the court will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 180 days of county jail, probated for a period of 12 months of community supervision, a fine of $150, plus repayment of court costs, 50 hours of community service,
Okay.
and then
How many hours of service?
50,
Okay.
and then completion of a drug and alcohol assessment with the completion of any recommended treatments.
So you just have an assessment, okay?
And then Mr. Coleman has 3 days credit to go towards his fine and court costs.
How much is this court cost? $277, so that's gonna take that one. You said it's 3 days credit?
Yes, Your Honor.
It's $300. Okay, now, Mr. Coleman. the state is offering that you serve 180 days in jail, but you will not have to serve any time in the Jefferson County Jail because you were placed on probation 1 year. During the 1 year probationary period, you'll be required to pay a fine of $100, $150 plus court costs is $277. You will be given 3 days credit toward the fine and court costs, which comes to a total of $427. You get 3 days credit, which you're gonna subtract 300 from that. That leaves a balance of $127 total fine and court costs. You'll be required to pay a probationary fee, $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $95 a month. Are you able to pay the $95 a month?
Yes, Your Honor.
Now,
I'm on Social Security.
Okay.
I'm away.
okay, hold on. Well, let me do this here. I noticed you did two things. You shook your head like this here, and then you say yes. So that signaled to me that you and then you said you'll find a way. Two things signal to me that you probably can't pay it. No, but that's not going to change what you worked out with the state. I just need to know that because there's some things that I'm required to do and that I can do by law. Do you understand that?
Yes.
So I assume you can't pay it. Is that correct?
Yes, Your Honor.
Okay. Now give him she's going to give you a form. We just need you to fill out it's an affidavit of indigence. It's right there. That's a pen right there.
Right now?
Yeah. You can have a seat at that table. Just put your name on and fill out that bottom portion. At the bottom, it has your income, if it applies to you, if you have income, and then on the left, on the right hand side at the bottom, it has your expenses, your bills. Okay, you fill that out, and let me do this. I'm gonna put this off the mic. Okay, we're back in session, house number 25 CCCR 2478. Case of style, State of Texas, Eric Dean Coleman. Now, Mr. Coleman, I have before me a document that is titled Affidavit of Indigence. And is everything on this document true and correct to the best of your knowledge?
Yes, Your Honor.
Okay, now, Mr. Coleman, the court is gonna find that you're indigent based on the finding of indigency pursuant to Article 42.15 of the Texas Code of Criminal Procedure. The fine of $150, court cost of $277. With 3 days credit comes to a total of $127. The $127 will be converted to 12 hours of community service. Okay. The probation fee in this case of $60 a month will be reduced to the statutory minimum of $25 a month. The restitution fee of $15 will be waived pursuant to Article 102.108 of the Texas Code of Criminal Procedure. And you will be required to pay your analysis fee of $15 a month. The total monthly installments, that is the total amount that you will be required to pay each month, is $44 a month. Are you able to pay the $44 each month?
Yes, Your Honor.
Okay. Now, you'll be required to have a drug and alcohol assessment. They'll determine whether or not you need any additional treatment. I know you just said you're currently in treatment and you had treatment, but you just need to have that assessment. Do you understand that?
Yes, sir.
You will also be required to perform 50 hours of community service. The 15 hours of community service is in addition to the 12 hours of community service, which comes to a total of 62 hours of community service. Do you understand that? All right. Now, you will also be required to adhere to the other standard terms and conditions of this probation. All right. Now, do you understand the state's offer?
Yes,
And do you accept the state's offer?
I do.
Okay. I'll follow the plea bargain agreement that you have entered with the state and with the findings the court previously made. You're going to have a seat because she has to redo the paperwork to include all of the adjustments that the court has made in your case. Okay.
Yes, sir.
All right. Just have a seat. Okay. Andres Ibarra. Mr. Bauer, your full name is Andres J. Ibarra.
Yes, sir.
Mr. Bauer, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You may put your hand down. How you doing, Mr. Bauer?
Mm.
You're doing fine. That's good. Now, Mr. Bauer, I have before me two documents. First document is titled Jefferson County Affidavit. That's titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled Defendant?
Yes, Your Honor.
Are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, Your Honor.
Also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, Your Honor.
On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, Your Honor.
Now, Mr. Ibarra, before you sign and initial these documents, did you read these documents?
Yes, Your Honor.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Mr. Bauer, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall.
I have a question.
Yes.
Do I qualify for the program? I don't have a criminal record.
Oh, you can talk to your attorney about that. Huh?
He's asking about pre-cooperation.
Yeah.
So we need to talk to him.
Yeah, talk to your attorney about that. He could get you in, submit the application
Thank you.
to get you into it. Okay. Kalen Jones. Oh, excuse me, Johnson. Kellen Johnson. Your middle name is pronounced Quade? Quad? Okay. Mr. Johnson, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Johnson?
Doing good.
That's good. Then, Mr. Johnson, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that's, he he didn't change it. He got it as he wanted to represent himself on that.
Hey, that's nice.
No, you didn't. You gotta mark this out and put the court already. And you got my people. Huh?
You have,
No.
Mosby, he made the change.
Go downstairs to the county clerk's office, you have to transfer them, okay? Right downstairs.
Okay, now, okay. I also have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. And are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
Now, before you signed, you have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Johnson, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Johnson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Our court reporter will give you that information. But before, once you get that information, you'll be free to go. You have a blessed day. Please have a seat in that first chair on the wall. Here you go. There you go. Yeah. Robert Hawkins. Okay, Mr. Hawkins. I have, Mr. Hawkins,
Hello, this is Mr. Morton.
you're,
Sorry, I'm sorry.
who's that?
Yes.
Okay, sir, you need
I
to put
apologize.
your
Yes, ma'am. Yes,
mic
sir.
on mute.
I'm sorry.
Okay, put your mic on mute and we'll get back to you.
Yes, sir. I'm so sorry. I don't.
Let's see, Mr. Hawkins. Your full name is Robert Lee Hawkins II?
Yes, sir.
Okay. Mr. Hawkins, would you please raise your right hand? Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Hawkins, you may put your hand down. How are you doing, Mr. Hawkins?
Yes.
I'm blessed as well. I'm doing fine. Now, Mr. Hawkins, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
Is this your signature on the line that's titled Defendant?
yes, sir.
And are these your initials on the line that state you would like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes.
Now, Mr. Hawkins, before you signed and initial these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Hawkins, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, the bailiff is going to give you a document that is titled Standard Bond Conditions in County Court at Law Number 2. And I'm going to go over this document with you. And it states as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and arrest the defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
I understand it, Judge, but I have a question on that, if it's okay if I ask you. I can ask.
Okay, the question, okay, regarding, yes.
To number 3, yes, sir. So, my case is against my wife. She did not press charges on me, but the state did pick it up. I know due to my bond conditions that I'm not able to have contact, but that is my place of residence. But due to my conditions, I've been staying at a residence house at my aunt's house, and this has been since October. I was asking the ADA, and he told me that he couldn't answer my question, so I had to get the court-appointed lawyer. So he told me I could ask you. Is there any way, or what can I do, or what's the necessary stuff? Because me and my wife are still.
Well, I can't give you any legal advice. I'll tell you this, you can't, if you violate these bond conditions, your bond can be revoked. And if your bond is revoked, the warrant is issued for your arrest.
Mhm.
Now, you just stated that you already have some conditions as well that's prohibiting you from having contact. And I do understand that on occasions, for these type charges, they usually have some type of temporary restraining order that's usually in place. Okay, but I can't give you any legal advice. You can talk to your attorney, and your attorney can, your attorney know what to do, and the attorney could, give you advice based on that. But if you violate any one of these conditions, your bond can be revoked. If your bond is revoked, a warrant will be issued for your arrest, and you'll be arrested and placed in Jefferson County Jail. Do you understand?
Yes, sir.
Okay, now condition number 4 does not apply because that only applies in a DWI case. Your case is not a DWI case. Condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, if you violate any one of these conditions, your bond will be revoked. If your bond is revoked, you'll be arrested, placed in the Jefferson County Jail. Now, you can have a seat in that first chair on the wall and wait for your name to call. There you go. Jason Young. Mr. Young, your full name is Jason Young Senior. Mr. Young, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. You may put your hand down. How are you doing, Mr. Young? I'm doing fine. Thanks for asking. Now, Mr. Young, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yeah.
Is this your signature on the line that's titled Defendant?
Yes.
Or are these your initials on the line that state you like to waive your right to an attorney and represent yourself?
Yes.
I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
Yes.
Is this your signature on the line that's titled Defendant? Mr. Young, before you sign and initial all of these documents that I've just shown you, did you, before you sign these documents, did you read the documents?
Yes,
Did you understand what you read?
yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Now, Mr. Young, you have talked to the prosecutor, is that correct? Yes, regarding this case. And did in that conversation with the prosecutor, you attempted to work out a plea bargain agreement? He made an offer to you regarding your case?
No, we never got to that point.
Okay, so on this case, you would like to have a trial?
Yeah.
Okay,
Not yet.
you pleaded not guilty, okay? No problem. Now, I need to go over something with you. I need to give you what is called a Ferretta warning, and that's pursuant to the case of Ferretta versus California, 422 US 806. And it's, now, first question, have you ever studied law?
No.
Have you ever represented yourself in a criminal action? Do you understand the charge against you? You've been charged with criminal trespass. Do you understand that charge? Okay. Are you aware of the maximum penalty for this charge? Well, it's a Class B misdemeanor. And as I mentioned to the panel, the folks that was in here earlier, the range of punishment for a Class B misdemeanor is 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Do you understand that?
Yeah.
Are you familiar with the exact legal elements of the charge? That is what the state has to prove.
No.
Okay. Do you realize that if you represent yourself, you're on your own? And as a judge, I cannot tell you how you should try your case or even advise you as to how to try your case. Do you understand that? I cannot help you in any way.
Yeah.
Are you familiar with the Texas rules of evidence and Texas case law?
No.
Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted, and in representing yourself, you must abide by those rules? So for example, do you know how to conduct a voir dire examination?
No.
Do you know what are the grounds for excusing a juror for cause?
No.
Do you know what is hearsay?
Yes.
Do you know what are some of the exceptions to hearsay?
No.
Do you know what is the proper way of impeaching a witness?
No.
Do you know when is character evidence allowed?
No.
Do you know when and how to make proper objections?
No.
Do you know when and how to move for a directed verdict?
No.
Do you know how to proffer evidence to protect a record for appeal?
No.
Do you know the proper grounds for mistrial?
No.
Are you aware that failure to timely move for mistrial may waive crucial mistakes made by the state or this court?
No.
Do you know how to request and object to jury instructions? Okay. Are you familiar with the Texas rules of criminal procedure?
No.
Do you realize that those rules govern the way in which a criminal action is tried in court?
No.
So I must advise you that, in my opinion, you would be far better defended by a trained lawyer than you can be by yourself. I think it is unwise for you to try to represent yourself. You are not familiar with the law. You are not familiar with the court procedures. You're not familiar with the rules of evidence. I would strongly urge you to not try to represent yourself. Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by an attorney?
Yes, I'll probably do a court appointed lawyer.
Okay, you want to see if you're qualified? Okay, we're gonna give you a form to fill out, that affidavit. Just have a seat at that table. Bailiff will hand the form to you. Okay, Mr. Martin? You
Yes,
can
sir.
take, okay, now, Mr. Martin, you zoomed in after the arraignment
Yes, sir.
and give us a reset date. So your case is going to be reset for you to be here in person.
Yes, sir.
Hold on a minute.
Get ready to come.
Okay, this case will be reset to February 10th,
Yes, sir.
2026 at 9 a.m.
Yes, sir.
Okay, February 10th, 2026 at 9 a.m. You need to be here in person. And you can stay in contact with your bondsman.
Yes, sir.
You're free to go
Thank you, Your Honor.
and you have a blessed day. You're
Yes, sir.
welcome.
Thank you, Your Honor. Okay.
You're welcome. Okay, you back on the record. Let's see, now, Mr. Young. Have before me a document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Mm.
On page 2 of this document, there's a signature. You know what? He has to change.
Oh,
On this here too. That's, yeah, 3. We can try it, it's here. That's true.
I just showed you where to mark it. There you go. That ain't changed. That's the real person.
Okay, now, Mr. Young, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. And I showed you this document earlier, but you made a change, is that correct? And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Now, Mr. Young, before you sign and initial these documents, did you read the documents? Did you understand what you read? I need that note. And is everything in these documents true and correct? Who's that? Everything in this document true and correct to the best of your knowledge?
Yeah.
Who's next? Okay, now, Mr. Young, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Laurie Perazzo. Attorney Perazzo will be given information to contact you, and you will be given information to contact her. The court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Did you write it down? Okay, have a seat in that first chair on the wall. And this will conclude the calling of the court's arraignment docket on the day's date, January 27th, 2026, in County Court at Law Number 2 of Jefferson County, Texas. And Mr. Hilton, you're free to go, and you have a blessed day.